Hi, hello, welcome to SQ Hungama and i3E by Karteek. Informative, innovative, inspirational, and entertainment show. Today, we have an immigration lawyer, Mr. Somi Reddy Santosh, with us in our show to discuss on the current topic, that is October 2020 visa bulletin. Welcome to the show, Santosh.
Hi, Karthik.
Yeah. So for everyone's convenience, like today we are going to do this show like in English as well as Telugu. So let us start with like this topic, October 2020 visa bulletin. That is, Santosh, what exactly is the priority date means here?
Okay. So, priority date is the date when the applicant actually files the labor application. Okay. So, if they're going through the perm process, it's a date they file the perm. Okay.
Okay.
If they're directly going for I-140, for example, if they're filing under national interest waiver or so, then the date will be the date when they file the I-140. Okay.
Okay.
So once you receive the approval I-140 approval notice, that notice will have the priority date for the person. It will also state the employment category under which the I-140 was approved, whether it's EB2, EB1, or EB3. Okay.
Yeah.
So once someone's priority date becomes current, okay, and if they are present in the US at that point of time, they can file for what is called adjustment of status. Okay. So when they file for adjustment of status, along with that, they can also apply for EAD and advanced payroll, which will allow them to work as well as travel while the green card application is still pending with USCIS.
Okay.
Okay. If the person is actually outside the country, outside the US, okay, then they cannot file for adjustment of status.
Okay.
So those people will have to go through consular notification. Okay. So do you have any questions regarding this part
Yes.
or?
Yes, yes. So you also asked, told us about like a priority date is current and that thing is covered. And could you please explain about this, what exactly this October 2020 visa bulletin is all about?
Sure. So what happened is because of the proclamation order, a lot of green card cases, family-based green card cases were not processed. Right.
Okay.
So department, since they were not issued, the green card, family-based green cards were not issued. So there is an overflow of these numbers which were transferred to the employment-based.
Okay.
Hence, the dates have moved drastically. So now, if you look at it, the priority date for EB2 India is May 11th of 2000. 15th May of 2011, and EB3 is 1st Jan of 2015. So
Okay.
anyone who has an approved I-140 with these priority dates, right, or any date before these priority dates, they're eligible to file for adjustment of status now.
Okay.
Okay, and this does not mean that they're going to get the green card right now. It could be years before they will get the green card, but at least they can file for adjustment of status now.
Okay. Yes.
Okay.
So,
Yeah, go ahead.
so, and initially there were some rumors about this dates, right? Which
Yeah.
dates to be used. So, what is all that about?
Okay. So typically the visa bulletin is issued by the Department of State. Department of State is the agency that issues like visas and the visas, right? So Department of State has issued the visa bulletin, which will have the final action dates as well as dates of filing. Okay.
Okay.
Once that is issued, USCIS will confirm whether we need to use the final action dates or dates of filing. If they don't mention
Okay.
anything, then we'll have to go with final action dates.
Okay.
Until September 2020 visa bulletin, USCIS was always using the final action dates. But luckily, in this visa bulletin, they have agreed to go with the dates of filing, because of which the dates have moved drastically. So now all those individuals who have their I-140 approved, right, and whether it's under EB3 or EB2, right? If it's under EB3, if their dates are is anything before Jan 15th of Jan 1st of 2015, or if they are under EB2, and if they have priority date anything before 15th May of 2011, they're eligible to file for adjustment of status.
Okay.
Okay, I know it is slightly disadvantageous for EB2 category individuals than EB3 category.
Okay.
But there is an option wherein if somebody with EB2 category and their prior date is in like 2012, 2013, right? They can port their priority date from EB2 to EB3 and file for adjustment of status at the same time. Okay, this can all be done at the same time, so there is no waiting period. So I'm telling you all this based on some of the questions that I've been receiving in the last 2 days.
Yes,
Okay?
yes.
So
Even
there
like
is no premium processing.
I have a couple of questions for you.
Yeah, sure. There is no premium processing available to process an application from EB2 to EB3 because you may not have the original labor with you. But you should be able to file for the I-140 application as well as the adjustment of status concurrently.
Okay.
Okay. And that will work.
Yeah.
Okay.
So
you don't have to do a new perm application because you'll be able to use the old EB2 perm to file the new I-140. Go ahead, Keith.
What about EB3? EB2 May 2013 priority date people, Santosh. Like,
yes.
Do they have any options for that?
Yes, I was speaking to, yeah. So as I mentioned, right? So for example, if somebody has EB2 date of May 2013, right?
Yes.
All they have to do is they have to file the I-140 and adjustment of status together. So this I-140 will port their priority date from EB2 to EB3. So now, since EB3 2013 is current, they should be able to file adjustment of status at the same time.
Okay.
So they don't have to go through the perm process again, but they just have to file this I-140 application. Their employer would be signing the I-140 application along with the adjustment of status documentation, and then we'll submit them concurrently.
Okay. So, like for filing this adjustment of status, exactly like, do we need to be in US, or if someone got stuck in India, so what about them? Like in this meanwhile period?
Yeah, you have to be in the US in order to file for adjustment of status. Unfortunately, there are a lot of individuals who are stuck in India right now. Especially, they have a few clients wherein H4 individuals got stuck in India. So they are pretty much out of luck because the only way that they will be eligible is if we request for consular notification by filing something called 824 form. Okay, but that will probably take months, and by then the dates will retrogress. Okay, so if there is anyone who is stuck in India or any other place, so I highly recommend that they travel back to the US as soon as possible. Okay, and travel back on H4 or H4, not on B1, B2, because if you travel back on B1, B2, then you'll be subject to the 60-day, 90-day rule, which could affect your case. So I recommend that you travel back on H1 or H4, and then file for the adjustment of status.
So and are there any we are hearing many things about date of birth certificate? So is it that mandatory, and what are the other options if someone not having this date of birth certificate?
Yeah. So for example, if somebody is born after 1970, right? The typically date of birth, the birth dates are considered to be recorded. So if a person is born after 1970 and does not have a birth certificate, then they can get a non-availability certificate, okay, and use their matriculation certificate or affidavits from parents or whoever, right? Whoever has first-hand knowledge about their birth, they can use that. For filing adjustment of status right now, if you do not have it handy, do not panic. Okay, still go ahead and file the application, and by the time you receive an RFE, you should be able to gather all those documentation and submit it at a later point of time. Okay. So as long as you have some proof to show that you were born in India, of course the passport is there, and then you'll have some matriculation certificate. Try to use whatever affidavits. Try to use whatever you have, and then submit the application. And then once there is an RFE, at that point of time, you'll be able to get the non-availability certificate.
Okay.
Okay. Um, sure. And if you have the birth certificate, it's very easy. And again, I actually had a citizenship case wherein the birth certificate, like I don't know how they got it, but they got it from some Gram Panchayat person. And it was like, so when they went for checking the certificate, it was not an original one, or it was not properly recorded. So please make sure whenever, like I'm sure like there are a lot of people who will be working using some agencies to get their birth certificates, but please make sure it is proper, like you can actually verify the information online before you accept any such birth certificates and you submit it to USCIS, because they will be checking everything.
Yes. Yes. And also about medicals. So during this COVID situation, like what about having medicals? Like, is it mandatory for the medical also for filing this?
So
And how the
medical,
validity of this medical is like
yeah,
about
yeah,
the validity of
yeah,
medical?
yeah. So when it comes to the medicals, right, you can either submit the medicals at the time of filing the petition, which is now, or when you receive an RFE, or at the time of interview. Okay,
Okay. Yeah.
right? So if you do not submit the application, the medicals now, you will not have the option of submitting the medicals anytime until you receive this RFE. Okay.
Okay.
And if for some reason you're outside the country, when you receive this RFE, you cannot get the medicals done, because the medicals done abroad will not be considered for filing adjustment of status.
Okay.
So if, for example, if somebody received an RFE and they are traveling abroad, or they're in India or somewhere, right? So they'll have to travel back to give the medicals.
Okay.
So if you want to avoid that situation, then please go ahead and submit the medicals now. But again, there is another catch here. You have to submit the medicals to USCIS within 60 days of obtaining them. So once you get the medicals, you have to submit it to USCIS within 60 days. And the medicals are valid only for 2 years. So if your application is not reviewed within the 2-year period, then they might again anyways issue the RFE. Okay.
Yeah.
So in this court situation, it's up to you whether you want to submit the medicals now or at a later point of time. But these are the challenges that you could face in future.
Yeah. So, and also, what are all other documents, Santosh, that everyone need to be ready with for filing this?
Good. Typically, we have been sending checklists to everybody. One of the things that I want to make sure they all submit is the I-944 form, which is the public charge liability form. I don't want anyone to miss that one, because that's very important. And there is a chance that they might even reject the petition if you do not submit the I-944 form. So it's very important that you file the I-944 form. And so all the primary applicants, for example, like who were, when I say primary applicant, the actual employee. Okay. The employee needs to sign the I-485J application, and their employer also has to sign the I-485J. So unless your employer signs the I-485J, your petition would not be considered.
Got it. Yeah.
Okay. So other than like, do you have any other questions, or because these are the common questions that I've been hearing in the recent past?
So about this I-944, like if 944 should be filed for all the applicants in a household, or it is only just for the primary applicant?
No, 944 has to be filed for each and every applicant, the primary applicant as well as the dependents. I-864, which is affidavit of support, has to be filed only for the dependents.
Okay. Yeah.
Okay. The primary applicant would not file the 864. We don't need that for the primary applicant, but for all the dependents, the primary applicant has to sign saying that he will take care of their financial liabilities. Okay. The primary applicant has to sign the I-485J along with his employer.
Okay.
Yeah. Also, I have been hearing a lot of situations where the I-140 is held up with the previous employer. Okay. In those cases, you could reach out to your employer, and if they are still willing, and as long as they did not withdraw your I-140, and if they're still willing to sponsor you for the GC position, then they can sign the I-485J application, and you should be able to file for the adjustment of status. Okay. The other thing is, when you are filing this application, you should have the intention to work for that employer. Okay.
Okay.
I know a lot of people have been asking me, hey, what's going to happen if I don't work for that employer? You may get the green card, but
Yeah.
when you go for a citizenship interview or any other or at any point of time, they might look at this documentation, and if they feel that okay, you didn't have the actual intent to work for that employer, or if the employer did not have the intention to hire you for the position, then they might consider it as a misrepresentation fraudulent application, and not only deny your citizenship application, but also deny your adjustment of the green card. So they might revoke your green card also. So just be careful when you get your green card. You need to work for that employer for at least 6 months minimum. I would say 1 year, but 6 months minimum. Okay. And if you are already employed with that employer, and then if you file the I-485 application while still employed with that employer, then you have the option of changing to a different employer after 180 days. And then once you move to the new employer, you should work in the same or similar occupation. And then you have to update your CAS by filing AC21, which is the same I-485G application.
Yeah. And one more question regarding this I-944. Like, what exactly does USCIS look for in I-944 for employment-based application?
Yes. USCIS wants to make sure that you did not receive any public benefits. Okay. Of course, there are few exceptions wherein they will allow, but typically, I don't think any of the employment-based individuals would be taking any sort of those public benefits, because they will not be applying for stamps, food stamps, and all that stuff, right? So I don't think it will be a problem. So when you are submitting this I-944, make sure you include a copy of your credit report, your medical insurance documents, any assets or liabilities that you have. In that way, you can show that you have sound financial background. And typically, for citizens from India, like those who are born in India and on employment based visas, that should not be a problem, because I have never encountered any situation where H-1B holders or did seek for public benefit, especially like stamps and all, because their income itself will be much higher than the national standard.
Yeah. And one more question we have here is like someone asking, like, if you downgrade to EB3, then EB2 is not valid anymore, or we are applicable for both with same labor?
Yes. So if you downgrade to EB3, right, your EB2 will still be valid and EB3 will be still valid. But once you downgrade and file adjustment of status, your application will be processed in the EB3 category.
Okay.
Okay. But if something were to go wrong with this one, you still have that EB2. One of the bigger challenges that you'll face when porting from EB2 to EB3 would be, now your employer has to show the ability to pay again from the date the PERM application was filed. For example, if PERM application was filed 10 years ago, right? Okay. So now the employer has to provide the 10 years of tax returns, okay, along with your W-2 forms, pay stubs, everything, to show that they actually have the ability to pay you from that priority date.
Okay. And here is one scenario like someone is facing, that is, I have I-140 approved in EB2 with previous employer. A few months before, he moved to a current employer now, who cannot file his GC or permit, and who has not
initiated the process.
Yeah. So he's asking that, can I ask my current employer to use the previous I-140 and file for EB2 downgrade and I-485 simultaneously?
No. That can only be done by his old employer. If the new employer wants to do it, then they have to redo the PERM process.
Mm-hmm.
Okay.
Okay.
So if he goes back to his old employer, then he can use that existing perm and downgrade it from
Okay.
EB2 to EB3. But if he wants to be with the new, if he wants to do it from the new employer, then he has to redo the whole process. He has to go through the whole process again. But he can
Okay.
retain the old priority date.
Yeah, okay. Okay. So yeah, and what about, and also here one more question, Santosh. Sorry, like
Yeah.
here we have another question, that is, what about if we downgrade EB2 to EB3 and during process EB2 got rejected? Do I still have EB2 or I will lose both the
Okay. I
status?
guess he was saying that EB3 rejected, not EB2 rejected. EB2 is already approved. From EB2 to EB3, when he is doing it, he is wondering like what's
EB3
going to
got
happen if
rejected.
EB3 is rejected.
EB3 got rejected.
Yeah.
Yeah.
Even if the EB3 gets rejected, he will still have that
Mhm.
EB2.
Okay. Okay.
Okay.
Yeah. Mhm. So yeah. Uh, so if someone is asking about EB2 to EB3 downgrade, since EB3 is ahead, what are the options?
Yeah. Best thing is since EB3 is ahead, and if they have to file
Mhm.
for adjustment of status, then they can always downgrade from EB2 to EB3.
Okay. So only that is the
Yeah.
option they have for this scenario.
Yeah.
Okay.
But if your EB2 date is before May 2011, just stick with EB2. Somebody was asking me whether, okay, hey, since EB3 dates are moving forward, should I just downgrade it just in case?
Okay.
Don't do that
Uh-huh.
because there are a lot of applications that will be filed under the EB3 category. And I'm definitely sure this will be like the EB3 category will be too much burden now.
Okay. Yeah. And someone is asking I'm currently in EB2, but instead of downgrading, can I just apply another one in EB3 category with the same LCA?
It's not the LCA, it's the PERM. PERM,
Maybe they might
right?
have.
That's what is
Mhm.
porting. That's what downgrading from EB2 to EB3. It's the same
Okay.
thing. So
Oh,
you'll use the
it's
same
the same.
PERM application and then just file an I-140.
Okay. Yeah. Yeah. Mostly like everyone are like with the same questions. I have I-140 approved in EB2 with the previous employer. After long wait, I moved to current employer who hasn't filed my GC yet. Can I ask my current employer to
No,
use? Yeah, we
current employer
already
cannot do
asked the
anything.
current employer. Yeah, yes, yes, that's true. Um, and someone is asking, can I go to India in this situation? Would it be okay for going for stamping there and coming back in the situation?
Well, if you are currently in the US and if your prior date is current, do not plan on traveling. Okay,
Okay.
just file for adjustment of status. Once you file for adjustment of status, I recommend that they wait until they get the advance payroll
Mhm.
because although of course there is an exception wherein you can travel on H1, I would not recommend taking the using such exceptions. I prefer
Okay.
if you stay in the country until you get the advance payroll.
Okay.
Okay, once you file for adjustment of status, I highly recommend that you stay until you get the advance payroll before you travel outside the country. Of course, there are certain exceptions for H1B visa holders and L1 visa holders, but I recommend that you do not use the exceptions if at all possible because you never know, maybe the officer does not look at it properly and you don't want to encounter any issues.
Yes, yes, yes.
Yeah,
Yeah.
because this happens once in a lifetime. So you don't want to take chances with the adjustment of status applications.
Yes, yes. So yeah, here we have one more question, Santosh. Like it is,
Yeah.
mm, I, I had secured EB3 I-140 approval and later upgraded to, so he had EB3 I-140 approval and later
To
upgraded to
EB2. Can
EB2
he use the
I-140
EB3? Yeah.
from
He can,
previous
as long as
employer.
that EB3 I-140 is not revoked, he can still use it.
Yeah, he's asking, as I'm still with current employer and my priority date is current now in EB3, can my employer directly file I-485 based on original secured EB3 I-140 approval.
Yes, he
Or
can do
do
that.
they? Mhm.
Yes, he can do that as long as they do not withdraw that I-140.
Okay.
Yeah, it
Yeah.
should not be a problem.
Nice. Yes, sir, I'm getting many questions, but based on the time we have, so because we also need to like thought of doing it in like like Telugu as well, so that uh, yeah. So Santosh, ప్రస్తుతం ఇప్పుడు జరుగుతున్న పరిణామాలు చూసుకుంటే యుఎస్ఏఎస్ నుంచి అక్టోబర్ 2020 వీసా బులెటిన్ యొక్క మెయిన్ ఉద్దేశం ఏంటి, అసలు ఏం జరుగుతుంది?
Okay. Karteek, yeah, priority dates ఉన్నాయి కదా, అవి ఈ EB3కి EB2కి మూవ్ అయ్యాయి అనమాట. And EB3 priority dates have moved until 2015 and EB2 have moved until May 2011. Okay.
Okay.
And I'm assuming that most like everybody understands English, right? And then
Yes,
అందరికి
yes,
ఇంగ్లీష్ వచ్చి కాబట్టి
yes.
we'll keep it
అంటే మనకి
short.
కొంచెం
So
ఛానల్
ఇప్పుడు ఏమి
కాబట్టి
అంటే, yeah,
తెలుగు వర్డ్స్ కూడా.
yeah. And then May 2000, like Jan 2015 లోపల priority dates ఉన్న వాళ్ళందరూ one way or the other they are eligible to file for adjustment of status. If if their employment category is in EB2, they can downgrade it to EB3 and then apply. Okay. And if they're already in EB3, they can apply directly. EB2 ఉన్న వాళ్ళు, if their priority date is before May 15th of 2011, they can apply directly for adjustment of status. ఈ అడ్జస్ట్మెంట్ ఆఫ్ స్టేటస్ అప్లై చేయాలంటే దే హ్యావ్ టు బీ ఇన్ ద యుఎస్. సో ఎవరైనా ఇక్కడ ఇండియాలో స్టక్ అయిన వాళ్ళు ఉంటే దెన్ దే కెన్ అటెండ్ వీసా అండ్ దే ఆర్ యాక్చువల్లీ అలౌవింగ్ వీసా ఇంటర్వ్యూస్. సో వీసా తీసుకొని దే కెన్ కమ్ బ్యాక్ టు ఇండియా, దే కెన్ కమ్ బ్యాక్ టు యుఎస్ అండ్ దెన్ ఫైల్ ఫర్ అడ్జస్ట్మెంట్ ఆఫ్ స్టేటస్.
Oh, nice. So Jan 2015 and May 2012.
2011.
2011, sorry. Oh.
Yeah.
Good, Santosh. Like as always, like thanks for your time. I know like you have been in a very hectic schedule and a very busy schedule as always. But thanks for coming to my show once again, and hope like you'll be coming to this i3 by show by Karteek in future as well. And
Sure, Karteek.
thank you once again.
Thank you, and I wish you all good luck. And I recommend that you all take advantage of the situation. Please don't take any chances. Make sure you file your applications properly, and because if you miss this chance now, it may be years before you get your green card, or maybe years before you will get an opportunity to file for adjustment of status. So I recommend everybody to gather their documentation, be proactive. Even if you're not able to get some of the documentation like medicals or birth certificates, do not worry or panic about it. Just go ahead and file for adjustment of status applications, and then wait until you receive the RFE. Okay. The other thing that I want to tell everyone is, I know the USCIS fees are changing drastically starting October 2nd. So a lot of individuals have been contacting us and asking, hey, Santosh, can I use the old USCIS dates, which are like pretty much half for the I-485 application, and then file the application on October 1st. Okay. I recommend that they should not, like, of course, if they are able to file the application properly, then fine. If not, please do not look at the money. Just even if the USCIS fees has increased, that's fine, as long as, but you want to make sure you don't miss the opportunity and file the applications properly without any errors. Okay, please don't hurry. You will have from you can submit the application between October 1st and October 30th, but of course I recommend that you file it before October 25th. In that way, even if there is an issue with the mail or whatever, you don't want to miss the application. So, but I recommend, like, don't worry about the new fees. Just go ahead and file the applications properly. Okay. Fine. And thank you, Karteek, for arranging the show. And I wish you good luck.
Yeah. Thanks, Santosh. Have a good day.